Good morning and welcome to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I am located at 1563 Main Street in Peckville, Pennsylvania, and I am here with you every Sunday at this time on this station from 8 to 9 a.m. to bring you, the landowner, the information that you need regarding natural gas development here in Pennsylvania. And I always like to start the show by noting that I do not, I have not, and I will not represent gas or pipeline companies. I represent Pennsylvania landowners, Pennsylvania property owners, Pennsylvania oil and gas right owners, not companies. And I represent people, landowners, again, gas right owners, for such items as oil and gas lease negotiations, reviews, and consultations on any document that you are presented as a property owner, as a gas right owner related to natural gas development. Also, of course, pipeline, water line agreements. I've done agreements now, I think, easily over 60 different companies, hundreds and hundreds of right-of-way agreements, which tells you the type of work that is out there and the type of experience that is available. It's available for you. So when you're facing your first one, there are people, at least I know about me, who have represented hundreds of landowners with many companies in successfully reaching pipeline right-of-way agreements and agreements that we maximize the financial compensation, how much money you're going to get. We need to get the most money that we possibly can. But then there's part two. We need to get you the most protections that we can to protect your property and to limit the authority that you are granting anytime you sign an agreement. Think about it. It's pretty common sense that a company, or whoever it may be, an individual, but in this case we're dealing with companies, that a company is going to want to have, when they have you sign an agreement, they're going to want to gain, they're going to want to receive as much authority as they possibly can by you signing the agreement. They don't want to limit their authority, they want to maximize their authority. What do we want to do? We want to limit it. And that's very, very important. Real simple example. If you sign an agreement that allows for multiple pipelines, and you're only going to get paid in most agreements for the first pipeline, well, you may see a second, a third, a fourth, and who knows, fifth or sixth pipeline installed on your property within your easement area, depending upon what you signed. I have dealt with a bunch of these agreements from the 1950s, where the people who signed the agreements in the 1950s didn't negotiate anything, And now they're coming back and companies are saying, hey, we're going to put another line in. And by the way, we have this agreement that you signed, or not you, but whoever owned the property in the 1950s. And that agreement allows us the authority to put another line in. And by the way, we only have to pay you $1 per rod. $1 per rod. What the heck's a rod? Well, a rod is a unit of measurement, which equals 16.5 feet. So for every 16.5 feet of pipeline that we install on your property under this 1958 is a common number, 1950s agreement, well, we only have to pay you $1 for every 16.5 feet of pipeline. Not good. In today's market, the lowest per foot price, that I like to ever see anyone sign at is $15 per foot. But listen, I'm stressing that's in unique situations where there's no leverage. I do not like $15 a foot. We're negotiating on FERC lines, which are these lines that the company actually has eminent domain and condemnation. And I've done a bunch of these files and representation of clients in these type of lines. And the last many agreements have all been well in excess of $50 a foot. Well in excess of $50 per foot. $50 per foot. Not $1 for every 16 and a half feet. No, $50 per foot. And if my math is right, that's $825. If you got $50 a foot, that is $825 for every 16 and a half feet. Where these old agreements that people signed and did not negotiate would give them $1. Had they limited this line, had they limited their initial agreement to one line only, and they got $50 a foot, which most of these clients got more than that, almost, I think all of them did, but most got more, let's just say most, they would receive $825 for every 16 and a half feet, where the person who didn't negotiate their agreement and allowed multiple lines would get $1 for every 16 and a half feet. The guy who did, the lady who did negotiate, who was smart, who put limitations in the agreement, who didn't just trust and rely on the company landman who works for the company, whose job is to get the best agreement for the company, not you, the landowner. No, they limited it to one line, which then gave us today the ability to negotiate at a price over $50 a foot. But let's say it was $50 a foot. Here you take one gentleman and you give him an easement area over his property where there was an old 1950s agreement that wasn't negotiated and had no limitations. And if that guy has a total of, and for easy math, we're going to say that two people have a pipeline on their property under my little scenario here that is a total length of 1,650 feet. So if you did not limit and you allowed for an additional pipeline at $1 a rod, your total payment would be $100. $100. That's it. Or if back in the 1950s, which some people did, negotiated to say as simple as just one pipeline only can be installed under this pipeline right-of-way agreement, only one line. Now we can renegotiate every future line. And if we get just $50 a foot, and because I say that because other people have received higher, $50 a foot would be on that same 1,650 foot line where the non-negotiated agreement would give the gentleman or lady $100. $50 a foot would give them $82,500. $82,500 versus $100. That's a great example, just an example. And there's so many different ways that this comes up, but just an example where simply understanding what we need to do to negotiate the most basic of basic terms, and there's so many more, but the most basic of basic terms could be the difference of, in the future, in this simple example, one person getting $100 and the other person getting $82,500. You got to get help, and you have to negotiate, learn your rights, and negotiate. And you need to do this before you make any commitments. And what's happening is people are committing, entering into agreements, not getting a review and consultation, not understanding what their rights are, and generally receiving less money than what they could receive if they negotiated, and almost certainly not getting as good of an agreement, not limiting the company, just giving the company what they want. And we need to stop doing that. The company wants something from you. They want you to sign a document. They want something from you. It's okay. That's okay. We need to say, okay, company wants something from us. Here's an opportunity. This is an opportunity for me to negotiate, and I am going to seize this opportunity. And the first thing I'm going to do is learn about, hey, what are my rights? What am I going to do? I'm going to call that guy, Doug Clark, commercial alert on the radio and find out, do a review and consultation and just see what I got here. Because I just had one the other day where the people were offered about 30 or 40 grand. We're going to sign for over 100 and some thousand. Again, doesn't happen all the time, but it happens a whole lot more than what you think. And you got to take advantage of that. And people, don't be afraid to pick up the phone and learn what we do. If you don't call us, call someone. But people are leaving tens and tens and tens and hundreds of thousands of dollars on the table because they don't realize their negotiation leverage. They don't. And if you are a company, you know these guys, this person will sign whatever you put in front of them. What are you going to put in front of them? Not a high-paying agreement, not a very tailored or narrow agreement. You're going to put a broad agreement for the lowest possible compensation you can, and that's generally what everyone's offered all the time. And if you're signing that offer, stop signing those offers. You're listening to All Things Marcellus with me, attorney Doug Clark of the Clark Law Firm. Remember, join me every Sunday right here, 8 to 9 on this station for All Things Marcellus. We need to negotiate these agreements. We need to do it, but we also need to negotiate them understanding our leverage. If you overestimate or overevaluate your leverage, you're going to not do what you're not going to do as good as you need to do, and you may blow a deal that you want. If you underestimate your leverage, you're not going to get as much compensation as you should receive or you could receive. You're also going to sign an inferior document that provides a lot more authority than what you should be granting the company. You need to. It's so critical to have a very accurate assessment of your leverage, and that's not easy. It's easier if you know what you're doing and you have experience, but as an individual, that's an extremely difficult thing to do. As an attorney, as you do 10 of these, as you do 20 of these, it's still very difficult. When you start to do hundreds of them and hundreds and 50, 60 different companies, you really get a sense of how to identify leverage, evaluate leverage, seeing how companies respond in various scenarios, seeing how that company responds in various scenarios, and then relaying that information to your landowner client and formulating a plan that is right for that individual. That, to me, is effective oil and gas representation by an attorney to their client. We need more of that. We need more of that. And certainly that's what I look to do in every single case. But we need more of that from other attorneys, and we need landowners to go out and get this information and stop just relying on the company. If the company landman says, oh, this is all they pay, what else is he going to say? Hey, here's a $10 offer, but they really pay $25. No. That's not what he's going to say. It's not what he's going to say. They're going to say this is all they're going to pay. If I had some money, let's put it that way, for every time a landman told me, well, the company's not going to do this, they're not going to do this, and then the company does it, I mean, hundreds upon hundreds of times. Hundreds and hundreds of times. They don't say, well, we may do that, and then do it later on. They say, no. We're not going to do that. We're not going to do that. Say, okay, well, if something changes, let me know. And then, sure enough, in many cases, not always, phone rings, we can do that. So you got to stop. We have to stop just blindly believing statements that are being made. We can't just say, well, the company said they're not going to do that. Or landman said, and he just seems like a pretty nice guy, they're not going to do that. So I better just go ahead and sign. What am I going to do? What's a lawyer going to do? What am I going to do? Hopefully you listen enough to know that this is not to just be some lawyer commercial, but I'll tell you what a good lawyer is going to do. They're going to advise you of your leverage, of your rights, of what happens if you say yes, of what happens if you say no. Where is the document good? Where is it weak? And they will, without a doubt, strengthen your agreement if they know what they're doing. And that could be by getting you tens and tens of thousands of more dollars, or even hundreds of thousands of dollars. Or that can be, at minimum, getting you better language, more limitations, and a stronger agreement for you, which is probably going to last many, 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 many decades into the future. Okay, let's wrap it up here. You were listening to first segment. I know there was panic across the community. No, we're not done. We're wrapping up the first segment. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. You can join me right here every Sunday on this station from 8 to 9 a.m., and I will be right back after this important message. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Don't forget, join me every Sunday, 8 to 9, right here on this station. So in case you're new to the show, I just want to remind everyone, if you're a regular listener, you'll know, but I've been doing the show since 2010. So we're in our seventh year of All Things Marcellus, seventh year. So if you're new to the show, you want to learn more, you want to learn more about me, Attorney Doug Clark, more about the Clark Law Firm, go check us out online. Go to pagasleaseattorney.com. Go to pipelineattorney.com, give us a call, learn about reviews and consultations or any other service. Do all matters relating to oil and gas here in Pennsylvania. Unitization, we're doing more with claims, complaints, actions against gas or pipeline companies, so interested in those as well. You can always reach out, give us a call, 570-307-0702. 570-307-0702. Please do not be deterred by distance. Don't be afraid of distance. I have clients all over the state, represented people all over the country, and even in other countries. So don't be afraid of distance. It virtually is never, ever an obstacle to representation. Very rarely, and if I feel that it is, I assure you, I will tell you right away, and we'll know and say, hey, well, unfortunately, this isn't something we're going to be able to work on, but that is very, very, very rare. So give us a call, 570-307-0702. And again, the radio show, today's show will be up and available on Monday. So you can go to pagasleaseattorney.com. You can go to pipelineattorney.com, and you can listen to today's show and many other shows. So if you're new to the show, go to the website, pagasleaseattorney.com, pipelineattorney.com, and listen to prior shows and check it out. Whether you're looking for representation or information, check out the websites. Again, I do not, have not, and will not represent oil and gas companies. Represent you, the Pennsylvania landowner. All right, so I'm going to jump a little bit. I want to talk about, I think it'll be brief. I want to talk about these gas lease offers out there. And if you're offered 12.5% royalty, 12.5% royalty, you better think long and hard before signing. However, there are some, rare, but there are some who I talk to, I consult with, and I say, hey, look, I think you need to sign this. And here's the reasons why. But I stress that is rare. And that usually occurs whenever the company is literally drilling, or they're about to drill, and that's a very gray area, or they've already started to drill, the unit's formed. There's certain very unusual, rare circumstances where I think, hey, look, you really need to do this. But in the vast majority of circumstances, and I mean vast majority, we need to think long and hard before we sign agreements at 12.5% royalty. This is not specific advice for anyone. No one. Not specific advice, but it is Well, here, I'll tell you. Specific advice to get your own specific advice. But here's a quick example. I did a review and consultation with a lady this week with an offer from Travis Peak. So if you're out there and you have a Travis Peak offer, turn up the radio a little bit. We talked about the idea that, yes, you're going to get some money up front for a bonus, not anything that was terribly substantial, but hey, there's an amount of money there. So we need to factor that in. And that is the most attractive part of this particular offer. Then this offer goes to, we start looking, and I have these threshold or these starting point, the big ticket items, I'll call them, that we got to look at first. And those are how much bonus per acre are you going to receive? Of course, that's the big bright number that the company always wants to post up in front of you and say, oh, you're going to get this, you're going to get this. Of course, they'll promise you future royalties of an exorbitant amount, but for now, they can only concretely point to, hey, here's your per acre bonus number. You're listening to All Things Marcellus with me, Attorney Doug Clark. So, okay, we're looking at the big ticket threshold items. So we got the per acre bonus, and then we say, well, what's the length of this agreement? What's the term? And all these agreements have what's called a primary term and then a secondary term. The primary term is usually 5 years. So that means that the company has 5 years to conduct what are called operations, which could be drilling, it could be filing for a permit. You need to understand that if you're going to sign a lease. But they have 5 years to conduct operations. Then if they do and they find gas, that lease will remain in place until there's no more gas to be produced. That could be easily 100 years or more. That's the truth. It could be 100 years or more. So too many people sign leases that have a 5-year term, and they hear, oh, I have a 5-year lease. And then they'll call the office here and they'll say, hey, my lease comes up next month. I'd like to negotiate. And they say, well, what's the status? What's going on? It's, well, I just started getting royalties. Well, if you're getting royalties, your lease as a general rule is not going to end. It is going to continue as long as there is gas being produced or capable of being produced. So when you have an agreement, the front number, that 5-year term, that's how long they have to do something, such as drilling. Once they do, that lease will extend for a very, very long time. So here's the term length in this offer, and other people had this offer. This is what it is. Tioga County, boy, they like to beat you guys up. So 10-year lease offer, 10 years. Again, I've never seen lease offers of 10 years being generally offered to people, except for Shell or Sweppy in Tioga County, and now Travis Peak in Tioga County. 10 years is a very long time. And imagine this. If somebody says, hey, we're going to offer you $1,000 an acre, but we want a 10-year lease. Well, if they were offering you a 5-year lease, would that mean they would be offering you $500 an acre? So you got to watch out. We have to watch for these very long leases, because that means instead of the company having 5 years to do something such as drilling, they now have 10 years. So they could wait 10 years before they even do anything. They start the drill or even file for a permit in most cases. So you have to be very, very cautious when considering a 10-year lease. I don't like them. Rarely do people sign them that I represent, but sometimes they do, because they evaluate everything, and in their specific circumstances, it may make sense. Here's an exaggerated circumstance, but here's an example. Say you have 200 acres and you're offered a 10-year lease, and say you're 80 years old, and you say, well, geez, I don't know if I'm going to live to be 120, so I think that my time may be somewhat limited. So if I could sign now and get $1,000 an acre, that would give me $200,000 since I have 200 acres. And even though the company has 10 years and there's a lot of time, I'm more interested in getting this money today because this will help with my retirement, things I want to do. Maybe it's going to help pay for some grandchildren's education, whatever it is that you want to do. But you say, hey, I'd like to do this now because if I don't sign, it may be 5 years or so until something comes along. So let me go ahead and do this because I'd like to go ahead and cash in on this money. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Join me right here every Sunday, 8 to 9 a.m. Okay, so I'm giving an example of when a person may be interested in a 10-year lease offer. I'm giving an exaggerated example. The person's 85 years old, has 200 acres, says, hey, I signed this 10-year lease, and I'm going to get $200,000. I don't know that I'm going to live for another 25 years. So, hey, I'm going to go ahead and cash in, and I don't really care so much about future royalties. And what I have sometimes in one case is the individual says, hey, look, I don't have any beneficiaries. I don't have anyone to leave this to. I'm not really concerned about future generations. I'm just concerned about myself right now. Well, in that case, then, hey, maybe that makes sense for that person. But maybe that person they're comfortable where they are in life. The money isn't going to change their circumstances. They have children, grandchildren, and they care a lot about the legacy of their family. And they know that, hey, I don't want to sign a 10-year lease, and could take a long time. But also, this leads us into the third really big factor. We want to look at the bonus. That's the simplest thing to look at. We want to look at the term. How long is the lease? 10 years, not good. 5 years, better. 10 years, not good. 5 years, better. We want to have the shortest term possible. Remember, this is not specific advice. This is general information. But generally speaking, you want to have the shortest term possible. So, okay, this leads us, what's the next thing we're going to look at? Well, you might have guessed it, royalty percentage. How much percent, or how much, what is the percentage of royalty that I'm going to receive? Well, the state law in Pennsylvania, the Commonwealth of Pennsylvania, the lowest royalty that a royalty owner can be paid under law, it cannot get worse. 12.5% royalty, or 1/8 is 12.5%. So if you are given an offer of 12.5% royalty, you better have a darn good reason to sign now, because in any future lease offer, you literally cannot do worse than 12.5%. So, do you want to, in most cases, sign a 10-year lease, lock yourself in for 10 years under a lease that pays you 12.5% royalty? Why are you going to do that? You really need to ask yourself those questions when considering such an offer. 10 years, the state lowest royalty, and allows for deductions. You've just locked yourself in. If you sign to a 10-year lease, the company needs to do nothing at all for 10 years. And all you're going to get, if there are royalties, is the lowest royalty allowed by Pennsylvania law. You're guaranteeing, you're locking in the lowest possible royalty. You've just locked it in for 10 years, and then maybe for the next century or more. Why are you going to do that? Well, there better be drilling happening right there. It's a question you need to be asking yourself. And if you're signing a 10-year lease and there's nothing going on, why lock yourself into a 10-year term with the lowest possible royalty percentage and that allows for deductions? You got to stop. We have to stop and look at that. Again, not specific advice. Specific advice is to get specific advice. but we got to ask that question. Why are you going to do that? And what happens if the market improves? We're seeing gas prices rise. We're seeing new pipeline projects being approved. Why sign today in a terrible market for a 10-year lease that allows for the maximum amount of deductions by law and that also guarantees that the most royalty you'll ever get is 12.5%, which is the lowest royalty allowed under law? If you're presented with that type of an agreement, you better have a darn good reason to sign it. And if you're going to sign, you should do a review and consultation and figure it out. Now, in this case, with the lady that I spoke to, it was pretty clear. We started talking about some of these problems, and she's like, okay, I don't need to go any further. I really understand, and I'm not interested in this offer at this time. This is a great example. Took probably about 1 hour, review and consultation, even looking at all the documents and having our conference. Took in total, and we did it by telephone. This person, I think, was in Philadelphia or maybe even Florida, but far away, and said, hey, thank you, but this isn't right for me. And I think that was a good decision for this person. But I don't make the decisions. The client, the landowner, the royalty owner, they make the decision. My job is to give you all of the information I can to aid and assist you in making the best decision for you. Now, sometimes that decision may be really, really clear. So I can really even say, hey, look, I think this is a really bad deal. I don't know. I don't think you should do it, but that's up to you. But usually the answers become apparent as you do the review and consultation, as you understand your circumstances, your leverage, and then you make an informed decision. Then you make the right decision. And I said earlier, maybe the right decision may be not to sign the lease. The right decision may be to negotiate aggressively because you might be able to obtain another $10, $20, $50, or $100,000 on top of what you're offered. You have to understand those things. You have to understand your leverage and your negotiation ability. And what I mean by that, I don't mean like your own personal negotiation ability, but your negotiation ability under your circumstances. And your leverage really can be completely different than your neighbor's. It really can. So when you're relying on your neighbor or you're relying on someone else, that is a major, major, major mistake, because they may not have done as well as they should have. They may have thought they knew what they were doing, but really didn't. They may have had an attorney, but that attorney may have not known what they were doing. Landmen and companies love when landowners have attorneys and sign bad agreements, because then they take that agreement to other landowners and say, Mr. Smith signed for this, and Mr. Smith had an attorney. So here, we'll offer you the same thing, and you'll get the benefit of Mr. Smith's attorney's work, and you won't have to pay for it. But the secret is, Mr. Smith's attorney did a terrible job. And they wish that Mr. Smith's attorney represented every single person in the county, because there would be a bunch of company-friendly agreements. Don't fall into the trap. There's not much relevance to what the neighbor did. We don't want to do worse, but there's not much relevance to what the neighbor did. We care about us, and we are going to be better negotiators. We're going to understand our leverage, and we're going to do better because we're more informed and we're more educated and we know what to do. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. You can join me here every Sunday from 8 to 9 a.m., and I'm going to be right back. Remember to give us a call. Learn about reviews and consultations, 570-307-0702. I'll be right back. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember, give us a call if you are presented with an agreement or any agreement. Give us a call, 570-307-0702. I represent landowners in all oil and gas related issues, and if nothing else, do a review and consultation and learn your rights. So important. Those reviews and consultations take an hour or two. I preach them all the time because they have been so successful for clients. I said the other day or earlier in the show, client calls, I think their offer is like 30 or 40 grand. They're going to sign for over $100,000 now for this project, and they were going to sign originally. So look, that doesn't happen all the time, but it happens a lot. It happens a lot. And these reviews and consultations, I've never had one where the landowner, royalty owner, property owner says, oh man, boy, that was a waste of time. It's never happened. It's never happened. So if you're given any oil and gas related agreement and you're considering signing, before you do, call 570-307-0702. Learn about our review and consultation service. I'm really confident that we can help you. And remember to tune in every Sunday from 8 to 9 a.m. right here in this station for all things Marcellus. So, okay, I was talking about this and happened to be an outline I started with the Travis Peak offer in Tioga County. Same principles and no matter where you are. But we're talking about, look, the first things you want to look at. What is the bonus you're being offered? How long is the lease? What is the royalty percentage that I'm being offered? And how are my royalties going to be calculated? And what I mean by that is if you had a 12.5% royalty, and that was, again, the lowest allowed by Pennsylvania law, but you had a really strong royalty calculation method, meaning that the company could not take deductions from your royalty, meaning that your 12.5% royalty would be calculated at the sale price that your gas is actually sold to a third unrelated, non-affiliated party. If you get 12.5% of that price that's at, say, the interstate pipeline point, I will take that every time over a 15, over a 16, and sometimes over a 20 or 25% royalty, depending upon how the royalty is calculated. I'm not going to go into it too much now, but I have in the past. Go check out pagasleaseattorney.com. Check out pipelineattorney.com. As we had about 5 years after everyone started signing leases, when people started getting their royalty payments and they were getting smashed by deductions from their royalty payments, as we saw that happen, I predict that in several years from now, and especially in Tioga County, but I see Chevron doing it in Southwestern, and I'm sure they're going to see it more and more from other companies. But companies are going to sell the gas to affiliated companies. They're going to use a fixed index price, which is going to be a low price, and your royalties are going to get smashed by index pricing and again, double whammy, index pricing and deductions. So I'll take a 12.5% royalty that's a legitimate 12.5% from a non-affiliated arm's length sale at the interstate pipeline before I'll take a 20 or 25% royalty from a sale that a company does to themselves at the well site, then pays me the index price, then takes deductions. That you're going to find is going to be deadly to your royalty payments. So royalty calculation is critical. And I've talked to very, very few people that understand how these royalty payments are going to be taken or made in the future and how these terms are going to be interpreted. Some people say manipulated. I'll say interpreted by the gas companies. You got to be careful. You got to be aware of it. And it gets back to, think about when you have all the pieces of information, you could be sitting there and say, I was going to sign this lease because I like certain things or I like the bonus. But then you look and you say, wow, if I sign this particular lease and whatever this case is, I am agreeing to 10 years to the company to decide even to drill or do anything. I'm locking in my royalty rate at 12.5%, which is the lowest I could ever do, ever. I can't do worse than that. It is literally impossible to do worse than 12.5%. I'm locking that in and giving the companies 10 years to decide to do anything. And then if they do, I'm locked in at that royalty rate for the next 50 to 100 years or maybe more. And then the company is going to be allowed to take deductions. And in some cases, they're going to use local index pricing. So if the gas was sold at $3, but the index price was $1 that month, then I'm going to get my gas calculated at $1, and then there are going to be deductions taken from that versus getting the $3 price without deductions. That is an enormous difference. And very, very few people understand it, and very few people know what's going to happen. And quite frankly, in my experience, I think very few landmen understand some of this stuff. But again, that's my opinion. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. You can join me right here every Sunday from 8 to 9 a.m. And give us a call, learn about reviews, consultations. If you're presented with any agreement or have any oil and gas related issue, claim against the gas company, claim against the pipeline company, give us a call, 570-307-0702. I represent Pennsylvania landowners. I don't, have not, will not, do not represent gas or pipeline companies. So while I'm talking about this royalty calculation and deductions, I just got to say something that just drives me crazy. It's driving me crazy. I am so tired of seeing addendum terms presented to landowners, gas right owners that have a royalty provision that says royalties without deductions, royalties, no deductions, or something like no deduction royalty clause. Companies are putting language in addendum with a heading that gives the absolute appearance that says, not appearance, it says royalty without deduction, no deduction royalty clause. And that's not what it actually is. And what I mean by that is how they get around this is they claim that we're not taking deductions. What we're doing is we're not giving you the benefit of transportation costs that we're paying. And I don't want to go too far down this, but what they're saying is it's literally, you hear this overused so much about semantics. What the companies say is, if your gas is sold at $2 and it cost us $1 in post-production costs like pipeline transportation, gathering, compression, or other fees. So it's sold at $2 and you have $1 in costs. What you want is you want the sale price. You want the $2. Deductions are when instead of getting your royalty at the $2 gas, they take deductions of the post-production costs. And those deductions are transportation, gathering, compression, and there can be others such as dehydration or others. So after deductions, if you take the $2 gas price that the gas was sold at, you take the dollar in deductions, now you have gas valued at $1 per unit. And if you're going to receive 12.5% royalty, which we want much better, but if you're going to receive that, you're going to receive 12.5% royalty based off of $1 gas instead of the $2 which the gas was sold at. So your goal is to have royalties without deductions so that you're going to get your royalty calculated at $2, not the $1 in my example. Well, here's, lo and behold, here's an addendum term, and I'm seeing this more and more and more. I see it in Tioga County the most, but I see it in other places too. You see an addendum term that says something like royalty without deduction, no deduction royalty clause. Very, very misleading. There's other ways that it's done too. So you believe that you're going to have no royalties deducted. And in some ways, what the company would argue is, oh, that's technically true. You want to talk about a loophole. This is a heck of a loophole. Technically true. What they say is that, yeah, even though we sold the gas at $2, we're going to pay you royalty based on $1. And you say, wait, what? Wait, I got to figure this out. What do you mean? I have royalty without deduction. and you sold it at $2, why are you going to give me royalties based on the price of $1 gas? And they say, well, you didn't understand this apparently, or you didn't go to an oil and gas attorney or someone who did understand it. And a lot of times I don't think the companies are explaining it to you, in most cases, in my opinion. But what happens is they say, well, yeah, you got to read this a little closer. And what it says is there'll be no deductions prior to the gas being placed into marketable form or being ready for sale or use, ready to be sold or ready to be used. So they'll tell you that, hey, the gas, the second it comes out of the ground, is ready to be sold or used, and it's in a marketable form. So therefore, it was worth $1, and we had expenses of $1 to get it to the sell point where we sold it at $2. So we spent $1, got it to $2 price, and we're not deducting the dollar in our cost and giving you royalty on $1. That's not what we're doing. We're just actually not giving you the benefit of us enhancing the gas from the wellhead. So again, what they say is, by moving the gas, which is ready to be sold or ready to be used, which is in a marketable form at the well, by moving that gas and taking it to the sell point, we have enhanced it. So yeah, we sold it for $2, but the value at the well was only $1, and the dollar in those cost and pipeline transportation fees, well, that was an enhancement that you don't get credit for. So you can call it a deduction, you can call it an enhancement, but here's what you have. Gas sold at $2, and you, as the landowner, getting royalty paid at $1. So most landowners say, wait, they're taking deductions. Company says, no, we're just not giving you the benefit of the enhancement. And that enhancement is simply moving the gas to market. So when you see that addendum term that says royalty without deduction, you need to understand what that means. Companies are smart. They know the buzzwords. They know what landowners say to landmen at their house. I don't want deductions. I don't want deductions. So imagine they say, well, put our thinking cap on. What do we do here? Well, I know. Let's label an addendum term royalty without deduction. Let's throw some very complicated, twisted language in there, and we'll go ahead and assign a lot more people because they think we're doing royalty without deductions. But in reality, most people would say, no, you're doing exactly what we didn't want you to do. You're just dressing it in different clothing. The old lipstick on the pig. All right, we're going to wrap this segment up here. You are listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Give us a call for lease review, pipeline review, any agreement review, or any other matter relating to oil and gas, claims against companies, claims against pipeline companies. Give us a call. Learn what we do. Love to hear from you. 570-307-0702. 570-307-0702. I'll be right back. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. You know, guys, I went way over on my earlier segments. What happens is we get into some of these more complicated discussions, and it's hard to find a breaking point. It really is. So went over a little bit. So I'm going to take this very short segment. I just want to stress, you hear me talk about these reviews and consultations. I want to stress again, this will be a little bit of a commercial segment, if you will, but I think there's value no matter what. Obviously, I wouldn't say it. But I'm doing all kinds of representation for landowners, and can't stress that enough. Whether you're people who are buying or selling gas rights, pipeline agreements, water lines, surface site, meter site, working on a quarry agreement, doing estate planning, royalty-related issues, claims against the gas company, breach of contract claims. There's a lot of that occurring. And, thankfully, we've been very busy because we've really focused on this landowner representation. And I learn things. I do this all the time. And I learn things every day. Every day. So that's where sometimes I'll say, yeah, well, people rely on their neighbors or they rely on other people. Be very careful. Be very careful, because there are things that I learn each week that I'm out here, fighting and working for landowners, that then I use and I implement that in future negotiations. And my knowledge base is always growing. And I want that to work for you. And what happens is when you're doing something in a vacuum, meaning just in your own negotiation, or you're getting what do you want to do? A lot of times you want to find out, well, what did my neighbor do? What does someone else do? Well, your ability to find that out is going to be fairly limited to those around you. And that's where someone like me, or if there's others out there that do what we do, that we can really give you that sample isn't just your neighbor. It isn't just your friend or the guy down the road or the people right around you that you talk to, or your cousin, or whatever the case may be. That sample is every other client that I've ever represented. We do those pipeline agreements. When I talk about doing agreements with over 60 different companies and hundreds of agreements, that's the knowledge base and experience we bring to each and every negotiation. And time has shown us that that is a very, very valuable thing. And don't be afraid. I think that too many people, especially as you get to some of these other areas of the state, get concerned about the distance. Do not be concerned about distance. We're here to help you. And if there's ever a thought that distance is going to be a problem, I assure you, I promise you, I will tell you right away. And it's rarely ever the case. So please consider reviews, consultations, get information, give us a call, learn what we do. 570-307-0702. 570-307-0702. I really want to hear from you guys. A lot of interesting things occurring in Susquehanna and Bradford County, Wyoming, Sullivan. Things are really picking up, doing more well site agreements, more pipeline agreements, and I'm confident that we can improve offers that you're receiving, usually financially, not always, but usually. But virtually, I can't remember a case where we did not improve the language or the terms of the agreement. And look, what my job is to do is to represent every client to the best of my ability, to do it efficiently. I don't make work up. And if I see that there's something that we're not able to do, then I'm going to tell you, hey, look, we're limited here in what we can do. Here's realistic expectations. Too many times, people are given these unrealistic expectations. And sometimes, unfortunately, people give people unrealistic expectations in order to get the individual to hire them for whatever the task may be. But that's not right. That's not right. What we need to do, and that's why I love reviews and consultations, is look at your situation, review it, have a consultation and say, hey, here's your situation, whether it be a pipeline, gas lease, any contract, here's your situation. Or if you think you have a claim against the gas or pipeline company, I sit down, we review all the documents, we review everything, and then we consult and we say, hey, here's what my opinion is. And if my opinion is, hey, look, I don't think you have a claim, then you get my honest best opinion. Or it may be, hey, I think you do, or I think you have a case here, or I think this is a good agreement, but we need to make some changes with the agreement, or hey, here's some potential problems, and give you my honest best advice from somebody who is focusing on oil and gas representation, representing landowners, royalty owners, not gas or pipeline companies. So remember, stop signing bad agreements. The gas and pipeline company landman work for the gas and pipeline companies, not you, the landowner. And if you want someone to work for you, the landowner, give me a call. Doug Clark, 570-307-0702. 570-307-0702. We'll catch you next week, 8 to 9 a.m. for all things Marcellus right here on this station. Have a great week, everyone.